This is entitled Rosemary Blair, Plaintiff Counter-Defendant versus Joseph Bowers and Carla Bowers, Defendant Counter-Plaintiffs. The actual reason for this hearing is a motion to withdraw as counsel filed by Mr. Hatch on behalf of the defendant Counter-Plaintiff Joseph O'Donnell and Carla Bowers. They are not present. I frankly hope that they would be here. This matter was on appeal in the circuit court for some time, and a decision was made on July 16th. Let's see who this is. And actually, I heard about it either by phone call or email or something while I was at Mackinac Island. Yeah. And then the actual order entered August 5th. Judge Stutzman's order regarding the appeal. Someone has joined us by telephone. Who's with us?
This is Carla Bowers.
All right. At any rate, I learned that Judge Stutzman had issued an order. I didn't see the order till I got back. Then I attempted to set this for a hearing quickly, but I was gone, and then the parties were gone, and somebody went camping, or I don't remember exactly what happened, but we ended up with today's date on the hearing for Mr. Hatch to withdraw. In my original order back in May of 2023, I was trying to issue a practical order that would bring a conclusion to the matter. It was appealed, and as indicated, it was on appeal for quite some time. Judge Stutzman's order that is issued August 5th says, it is hereby ordered that Rosemary Blair's motion to set aside judgment and certain orders entered in part by the district court for lack of subject matter jurisdiction is hereby granted in part. Specifically, the default that was entered in count 1, 3, 4, 7, 8, and 9 is vacated and is in no force and effect. I didn't think I did a default in those matters. My order transferred jurisdiction on those counts to the circuit court. So I don't believe they were defaulted. They were just transferred to the circuit court because of the subject matter jurisdiction. Then it goes on to say that count 1, 3, 4, 7, 8, 9, 10, and 11 have been transferred to the circuit court and no findings have been made with respect to these claims. So those matters are still pending in the circuit court. And it's difficult to know exactly what's what by just referring to them as counts, but he further orders that count 2, 5, and 6 of the counterclaim remain with the district court, and the district court retains jurisdiction of those claims. He goes on to say that my order of July 31st ordering Rosemary Blair to return personal property is vacated, as he believes I did not have the authority to do that. But counts 2, 5, and 6 of the counterclaim remain. He's referring to my order of, I'm not sure our dates match, but I'm referring to my order of.
It's July 31st, Your Honor.
Yeah, July 31. On its face, it says May 22nd, but it was actually signed on July 31. As to count 2, specific performance, here is Joe O'Donnell, late to the party, but he is here. Good afternoon, Mr. O'Donnell.
Good afternoon, Your Honor.
You're a little late to the hearing. I've been reciting some of the history of the matter, but Mr. Hatch is here and Mr. Soltis is here.
Oh, I'm sorry. I thought it was 1:20.
No, it was 1:15. At any rate, my original orders, count 2 stands, specific performance. It is ordered that Blair shall deposit $5,000 to be held in escrow for consideration of the lease with option to purchase. It is further ordered that the defendant counter-plaintiff shall be entitled to application of all escrow funds currently held by the court. It is further ordered defendants counter-plaintiffs shall continue to make payments consistent with the escrow orders, $2,000 per month, and that has been modified. Defendants counter-plaintiffs shall pay the 2023 property taxes relating to the property. And the other counts, as I indicated, were transferred to the circuit court. I also ordered that in May, that defendant was entitled to specific performance of the contract. So Mr. O'Donnell, Mr. Hatch has filed a motion to withdraw as your lawyer. He filed a similar motion in circuit court that was granted. I waited until Judge Stutzman ruled on that matter until I ruled on this matter. Before I let him out and ask you about that, I want to ask both attorneys, Mr. Hatch, what is your understanding of the current posture of this case?
I think the court did a great resuscitation of where we're at, Your Honor. I can just clarify with the actual names of the counts that were transferred to the circuit court and those that retain in the district court. The order entered by Judge Stutzman on August 5th was really what I see as a clarifying order more than, well, first, Mr. Soltis never filed an appeal to the circuit court. He filed an actual motion once the claims were transferred to the circuit court, which is distinct from an appeal, which was one of the arguments that he missed the deadline to appeal the district court's action, except those for subject matter jurisdiction. So really, I see Judge Stutzman's order as clarifying. And I agree, count 1, 3, 4, 7, 8, 9, 10, and 11. To the extent a default was entered in those claims, that default was set aside by this court, and those claims were then transferred to the circuit court. So I don't really see that as overturning any actions of the district court, because count 1, 3, 4, 7, 8, 9, 10, and 11 are in the circuit court, and those were transferred without a default being entered. Count 1, 3, 4, 7, 8, 9, 10, and 11 in the second paragraph, it just says what we effectuated in the district court, that those were transferred to the circuit court. That's the second paragraph of his order. And counts 2, 5, and 6, it just clarifies that those remain in the district court and that the district court has jurisdiction over those claims. Count 2 is specific performance, which is what this court's July 31st, 2023 order after our bench trial relates to. Count 5 of the counterclaim is summary proceeding for possession of property. Obviously, the district court has exclusive jurisdiction over that claim and retains jurisdiction. And count 6 is quiet title. So specific performance, count 2, summary proceeding, count 5, and quiet title, count 6 remain in the district courts, pending in front of the district courts. The order goes on. The only thing that I really see that Judge Stutzman did to overturn or affect any orders of the district court was the last paragraph where it states that the portion of the court's July 31st, 2025 order, which was the order after we had a bench trial in this case, that requires Rosemary Blair to return all personal property identified by Joseph O'Donnell and Carla Bowers, is vacated. He felt that the district court did not have jurisdiction. We've gone through that, but just for purposes of the record, I do want to note MCL 600.8303 states the district court shall have the same power as the circuit court with respect to civil actions to recover the possession of goods or chattels. We feel that that is very clear, that the district court has jurisdiction to order the personal property, goods, or chattels to be returned, but that is what Judge Stutzman ordered. So that's really as far as his August 5th order.
Well,
the only thing
that wasn't the first time I'd ever made such an order. Sometimes it comes up as an ancillary issue, but he saw it differently than I did, so I'm bound by his order. But as a practical matter, has all that property already been turned over?
None of it's been turned over.
Okay, so so now they don't have to because of Judge Stutzman's order.
Right.
Your Honor, if I may, I disagree with Mr. Hatch in the extent that Mr. O'Donnell and Ms. Bowers have possession of two boats.
That's
One
not true.
pontoon boat, the other one is, I'll call it for lack of other word, speedboat. And those have been in the possession of Mr. O'Donnell and Ms. Bowers after this court made that order to turn them over. So they've had possession. Rosemary Blair has not had possession. We don't know where they are at this point, frankly, but
Judge,
So let me stop for a minute. Let me stop. Don't say anything at this point. Yeah,
Sure.
well, I believe I have the authority to make everybody give this stuff back. No, those are a little different because those items are titled. A paddle board or a canoe or a kayak or furniture is not subject to title. Those items are titled and they actually belong to the title holder. But all right, so nobody got their stuff back while this matter was pending. And now Judge Stutzman said that portion of my order is vacated. So there's no order regarding that. All right. The matters that are in circuit court, are they still lingering there? Or have those been resolved? Are there these 6 counts still in circuit court?
they have not been resolved. As I recall, correct me if I'm wrong, Mr. Hatch, is that Judge Stutzman allowed Mr. Hatch to withdraw and gave Mr. O'Donnell and Ms. Bowers 60 days to either find new counsel or appear on their own behalf. That 60 days will be up about October 2nd.
Correct, Your Honor. The last paragraph of the order granting my motion to withdraw in the circuit court requires Mr. O'Donnell and Ms. Bowers to file appearances in the circuit court action either through an attorney or impro per within 60 days. And then also provide their information like their address, phone number, and email, not by way of the order, but just to the court. So it's not public record.
So those matters are still in circuit court and our matters are still in district court. Ms. Bowers, I can't see you, but I know you're here. Mr. O'Donnell is here. I'll ask you first, Mr. O'Donnell, what's your position regarding Mr. Hatch's motion to withdraw?
Well, I mean, I believe Carla and I both agree that we really are kind of just still like in awe and not really knowing what's going on. And I mean, we still need time. And I understood the circuit court judge is 60 days. And, and we've just been trying to figure out what's going on. And we still don't fully understand the case. And, our biggest concern right now is that we're not going to have any of these files and stuff. And Judge Stutzman made it sound like we have to redo the whole trial, redo everything. And now I don't know, we never got copies of anything, of any of the motions or any of that stuff. So we don't really have, copies of anything. So we're gonna have to start all over. And, and the cost bearing of all that
Certainly
stuff
you will
is gonna be
provide
so-
everything, but my fundamental question is, do you object to Mr. Hatch withdrawing?
I mean, yes, just for the fact that, I feel like that we're in so much trouble without him because he's the only one. This case is so thick and so complex and so detailed. And I don't even understand him. We relied on him implicitly for everything. And now it's kind of, I don't know what to say. It's just, we're just in the worst
All right,
spot.
well, let me ask Ms. Bowers, do you object to him withdrawing as well?
Absolutely. I don't, honestly, there's no way we can afford to have this case start over. We're just getting screwed left and right here on this house.
Well, I don't propose to start over again. What I would like to do is get at least the district court portion of this case to the finish line. I'm ashamed of the legal system that it's taken this long to try to resolve this case. Now, most of the things that I do in
Can I also say, like, this is a very, very big financial burden because there's a whole nother
I
house, a whole nother property.
I understand, which is why we're in the posture we're in. So when the case takes as long as this has to resolve, it costs everybody a bunch of money, not to mention Rosemary Blair and her family. They've paid 3 attorneys, now 4 with Mr. Soltis. The property status is still unclear. I haven't been out there. I heard the place is not looking good. I was told it looked like it was abandoned.
The docks of the water and everything, Your Honor.
Okay. And we heard all the testimony. I was not pleased with the way this happened. The zoning officer came in there and did a summary immediate eviction of Mr. O'Donnell and Miss Bowers. They had to move, the kids had to change schools. It was a financial strain on both of them, on their finances, on their relationship with their family. Miss Blair either wanted to complete this sale or get the property back so she could sell it. The world is different now than it was in 2022 and 2023. Interest rates were at 3.5%. Property values have gone up since then. Interest rates are now substantially higher. The parties had to pay escrow. Somebody had to pay the tax. It was a non-homestead property. So yes, I'm aware this was hard on everybody. And I would like to get some sort of resolution of it. Judge Stutzman referred the matter to mediation, which I didn't think was going to be successful, but I think they do that in every case. And that was part of the delay. Might be ready for mediation now, but at that point, they had my order, specific performance. They're ready to pay the price, apply the escrow funds, and the money was paid to the purchase price, take out a loan for the balance, and take title to the house. Miss Blair would have gotten several $100,000. O'Donnell and Bowers would have had the house, and there would have been closure, but it didn't go that way.
Your Honor.
So what I don't want to do is fight about it for 5 more years. So Mr. Hatch, I share some of the same concerns they do. You filed a lot of extensive pleadings, claims, counterclaims, multiple counts, multiple theories. They're not attorneys. This has to do with whether you're being paid for your services. So Mr. O'Donnell and Miss Bowers, this isn't a court-appointed attorney case. You hired Mr. Hatch to represent you in this matter, and he represents that you failed to pay him or even have much contact with him. And he feels because of those reasons, the relationship, the attorney-client relationship is broken down. So he asked to withdraw. Now, granted, whoever would be willing to take this case, bless them. Mr. Soltis was willing to dive in the middle of it, but I'm not sure anybody else would want to get into this case. It would be very difficult for you two to represent yourself in a pro-per situation. Mr. Hatch, have you and Mr. Soltis, I'm sure you have, talked about trying to get some resolution here since Judge Stutzman's opinion?
I have not, Your Honor. Since Judge Stutzman's opinion, because the motion granting my withdrawal, can't talk to him about the claims in the circuit court case because I don't represent Mr. O'Donnell and Miss Bowers anymore. Those are really the pending claims. Really, I mean, I think this court did an incredible job for the bench trial that we had, putting this on a nice silver platter about trying to wrap it up. And specific performance was granted. We have an order on who gets the property and when. That's contingent upon, you know, a payment of the remaining balance of the lease with option to purchase. I'm not calling it a land contract anymore. Mr. Soltis doesn't like that. So
Thank you.
that's no problem. The issue is that I don't represent Mr. O'Donnell, Miss Bowers with respect to the bigger issue, which is the damages that they assert against Rosemary Blair that are through counts 1, 3, 4, 7, 8, 9, 10, and 11 that remain in the circuit court.
Well, and the issue with that, Miss O'Donnell and Miss Bowers, is that you were hopeful to offset the purchase price by a damage award on your claims in the circuit court. And so let's just pick a number out of the air. Let's just say circuit court granted $50,000 in damages. That could have been applied toward the purchase price and would reduce the price. Those claims are not going to be resolved anytime soon. My order, and we're going to have to look at timeframes, that you purchase the house for the agreed upon price with the set off of the money that's already been paid and the escrow money stands. So you and Ms. Bowers, you and Mr. O'Donnell are going to have the opportunity to purchase this house under that original agreement to purchase it. The time limits have all expired, so I'll set some sort of time limit. One of your remedies is to buy the house for that price. I ordered that she sell it at that price. Then you could continue your fight in circuit court regarding money damages. Mr. Soltis, do you agree with that analysis?
To some extent, Your Honor, basically, yes.
All right.
What happens if $1,000 lien that's against the house that she was not forthcoming about?
Say that again. I didn't understand what you said.
$186,000 outstanding in her federal tax liens against the house right now. It's almost $200,000. I went to the courthouse, pulled it up like last week.
I was not aware of that. $286,000.
180, no, it's 187,000. I think it's higher than that now though, but that was just the ones I could pull up that weren't, that's for federal tax liens she's had on there starting in like 2009 or something like that, or 8. And they're all on there. So they're all on that property. I don't think that those federal tax liens, I think, stick with the property, and they have to be for the property to pass title. You have to pay those off.
Judge, if I could just add, I think that as far as the dates go about when Mr. O'Donnell and Miss Bowers are bound to purchase the house under your order, I think that is necessarily tied to the circuit court action because on page 3, it says it is further ordered that when a damage figure is established by the circuit court, defendants, counter-plaintiff shall have 90 days to execute the option to purchase and the lease.
Right, so 90 days from the decision of the circuit court. And I'll be retired before that happens. I'm not being flip. I'd stay longer if I could, but the Supreme Court tells me I have to go next December 31. And Mr. O'Donnell, you may have to make the hard decision that, and Miss Bowers, Miss Bowers, the reason I can see him, I can't see you. All I see is a silhouette of a icon of a telephone. So I tend to address him because I can see him, but I understand that you're also there. This is the first I've been aware of this tax lien question. She can't give you title to the house absent the tax lien being cleared.
I think
Ms.
that's
Stiver, do you have any knowledge? Just a minute. Ms. Stiver, do you have any knowledge of any of that stuff? Ms. Stiver, can you hear me?
Yes, I'm sorry. Go ahead.
Are you aware of those tax liens?
No, I'm not. I'm not involved in all that. Nope.
Mr. Soltis, were you aware of it?
I was aware there were tax liens, Your Honor. I didn't know the amount.
So again, I would still like to find a solution to this problem that doesn't cost tens of thousands of dollars of legal fees for the plaintiff and the defendant. I'm not sure that's possible. I had ordered specific performance. Mr. Hatch prepared the order and he reminded me that that specific performance is attached to the circuit court damage hearing. I suppose. All right, the purchase price, as I recall, was $425,000.
450, I believe.
450.
I think.
Mr. O'Donnell, I don't have that order in front of me. 450. And that was 425.
Could have been. I don't remember.
$450,000, Your Honor.
All right, he's right. So there was $107,000 and then whatever's been paid into escrow. So it's probably about $300,000 to complete the sale of the property. But somehow the tax lien has got to be lifted before she can give you title. I'm not sure. It's a federal tax lien. I'm not sure what that's all about.
Income tax.
All right, so
I think
the
that's
question that's before us today is, does Mr. Hatch get to withdraw? Have you, Ms. Bowers, or you, Mr. O'Donnell, consulted with any other attorney?
Not yet, Your Honor.
I can afford another attorney. I mean, not to restart this. I mean, I don't know what I'm gonna do, but no, I haven't.
Well, and you're right. No attorney's gonna want this. Your last attorney
I wouldn't.
withdrew because he didn't get paid, or asked to withdraw because he didn't get paid.
He got paid
And-
quite a bit.
Yeah, well, I understand. I think the bill is much higher than you originally thought it was gonna be when you got into this matter. I don't want to necessarily know what it is, but I'm understanding it's probably substantial. A lot of time and effort has been put into this.
We have paid a lot so far. It's not like we haven't
Yes.
paid anything.
I understand. You paid substantially. I had a murder case once where I was prosecutor at the time. They hired a firm from South Bend that was quite renowned and expensive and paid a substantial retainer. And they did some exhaustive pretrial work, used up the retainer, moved to withdraw, and a public defender got stuck with the case for $5 and tried the murder case, and she was convicted, and they drew a substantial fee for the work that they had done, but withdrew before the case went to trial. So Mr. Hatch did a nice job of setting out the standard in his brief. In addition to the issues regarding payment, it appears there's just also been a further breakdown of the relationship with lack of communication and lack of contact.
Your Honor,
So-
there's no communication without payment, so that's the problem.
Yes.
We tried communicating, but there was no, unless we paid, there was no communication. That's what we were told. You know, are you going to pay or we're not going to talk to you? Okay. They know we don't have the money.
It's not true, Your Honor, but I'm not gonna get into that on the record. And I'm not gonna betray client confidences, and I would instruct Mr. O'Donnell and Ms. Bowers that to maintain the attorney-client privilege. If you want to waive that, then you can talk about what you and I talked about on the record.
Well, all right. Mr. Soltis, I didn't ask your opinion. This sort of isn't your fight, but you're entitled to give me your thoughts on this motion.
Your Honor, I have no dog in this fight. just an interested observer.
You sort of do. Absent counsel, you're going to be dealing directly with Carla Bowers and Joe O'Donnell, who don't understand the law and don't understand the complicated circumstance they're in. And it's going to be a lot more difficult for you without counsel on the other side. But certainly you've been in the same circumstance where you've had clients that weren't able to pay for your services. So if I do grant the motion to withdraw, I don't believe you're going to have counsel. Counsel is already withdrawn in the circuit court. I'm stuck in neutral in the district court because I can't do anything until there's a ruling on the damage hearing in circuit court. And you two are going to have to present your claims in circuit court for damages. And they're hard enough in district court. They're harder still in the circuit court. You'll be acting as your attorney, asking for tens of thousands of dollars worth of damages to be offset against the purchase price of this house and my specific performance order. Mr. Hatch or Mr. Soltis, do you see any path to the finish line? When Miss Blair was last here, she said, I just want to get my money and get this matter over with. And I know this has been very frustrating for her. And she's probably close to 90 years old. And this has been a difficult process for her as well. Just a minute. Mr. O'Donnell, I'm not going to do this while you're driving.
I was just moving across a parking spot, Your Honor. I'm not on the road.
All right. Are you at the airport?
No, I'm in Chicago.
All right. Yeah, I don't want to do it while you're driving.
Oh, I wasn't driving.
Okay. So let me ask that question again. I'll start with you, Mr. Hatch. I'm not telling you that you don't know. The O'Donnells are going to be floundering fish out of water. Mr. Soltis is going to have to deal with that on behalf of his client. My summary disposition order, my specific performance is in effect. Is there some way we could agree on terms of purchase and transfer of this house?
I would like to, Your Honor. I think my clients would be open to that. We've posed that option at the mediation that we were ordered to go to in the circuit court. And I actually think that was a good use of our time because we resolved our claims with Mr. Verpalot. We resolved our claims with Ms. Stiver and Mr. Patrick Blair.
Can I say something? I don't know if you know it. Patrick passed away.
Yes, I'm aware of that. Somebody provided me with the death certificate.
I did. He died in June 16th. He had a tumor on his brain.
He was your brother?
No, he was my significant other. I was married and I divorced him and then we got back together. Okay. So I was taking care of him from he got released February 21st and he passed away in June 16th.
I'm sorry to hear that, Ms. Stiver. I didn't know about that.
Yes, it was not good. It was hard, very, very hard. And I don't wish this on anybody because I took care of him. I had hospice come in and everything in my home.
Okay.
Okay. Wanted you to know.
So good. That's good to hear. Because now we're just dealing with the sale of this house. Anyway, you were starting to say there was a proposal that was put forward at mediation.
And it was obviously there's rules that protect communications during mediation. All I say, Your Honor, is you can't force snow to go up. We've tried to resolve this in many different ways, shapes, and forms that I think that were very reasonable, but we have not been able to come to any agreement with respect to what the purchase price is, how to transfer the property, what property is to be transferred between personal property and returned, or where that might be. So we've given it the college try, but I don't see, unless things have changed since mediation, I don't see a path forward without, the circuit court calling balls and strikes as far as damages, and then it being, that damage amount being transferred back or offset from the purchase price pursuant to this court's order of July 31st. But I'm open to it, Your Honor. But again, at a certain point, I think we need to, I'm happy to try to resolve this with Mr. Soltis, but the fact remains that we filed a motion to withdraw under Rule 1.16 because there has been no payment and it is unreasonable financial burden on my firm. My hands are tied. I like Mr. O'Donnell. I very much like Miss Bowers. I tried this case for them. They became friends over this period of time. I understood probably one of the most difficult, parts of their life. And I think I represented them zealously in the bench trial in the district courts. We had some significant briefing in the circuit courts. Miss Blair doesn't go down without a fight. But the fact remains is that I am not on this case pro bono. If Mr. O'Donnell and Miss Bowers don't have the financial means to pay for a lawyer, there is legal services of West Michigan and Southwest Michigan that they do need to qualify based on income requirements. But they need to make a determination about what they want to do with this case moving forward. And if they want me to represent them, which I would be honored to do, to continue on this case, they need to pay my outstanding fees, because my firm will not continue to let me represent them. And I'm not going to get into it, but it is a significant amount of outstanding fees that have not been fulfilled. And under the applicable rules, MRCP 1.16 and the Court of Appeals, that says this court can look to the model rules of professional conduct to determine whether or not to grant a motion to withdraw. We would submit that there are grounds to withdraw without payment, and there has been no payment.
But Your Honor, there has been payment, like more payment than is owed, if that makes any difference. I mean, we paid more than we owe.
Yes,
So-
but I understand you paid a significant amount of money. I won't probably disagree with that. But once the matter got transferred to circuit court, there was an appeal, there were further hearings, there was a lot of there was mediation, there may have been some depositions. The bill didn't stop. If it had been resolved with my ruling, the bill would have ended then and that would have been done. But it wasn't exactly appealed, but the matter was asked for further hearing in circuit court. And it was going to go to circuit court anyway, because the whole other issues of damages and the other things that district court doesn't have jurisdiction over, it was going to circuit court no matter what. And Mr. Hatch doesn't work for free, and his law firm doesn't work for free, and his partners in his firm are saying, what's going on with this case? And here we are. So Mr. Soltis, some time has passed since that first attempt at mediation. Mr. Hatch thinks they went as far as they could without getting there. Do you have any thoughts on that?
Well, the only thing I can say is Mr. Hatch and I disagree on what is reasonable. And I don't think that will change.
And there's this issue of the tax liens. Let's assume that there's no damages. So about $300,000 is owed. So O'Donnell and Bowers would purchase the price for the balance of $300,000. If all that went to the tax lien, Ms. Blair would get about $13,000 or something, and if they're $287,000. So it's complicated. And but Mr. O'Donnell and Miss Bowers, if I were to allow Mr. Hatch to withdraw, like Judge Stutzman did, you'd be given time to hire another lawyer. It's going to be very difficult for you to hire another lawyer. One, the case is very complicated. Two, your last lawyer withdrew for failure to pay. So no one's going to want to touch this with a 10-foot pole. You're not going to be eligible for legal aid services on the purchase of a $450,000 house. So that ain't happening. Which means you're going to be left to your own devices and your own representation in circuit court. Mr. Soltis will probably file motions on behalf of Mrs. Blair, and you're going to have to answer those in proper Michigan court rule pleadings, or they won't even accept them. So you could probably secure financing to purchase this house. It's an asset. The current price is probably less than what the house is presently worth. And you could finance the purchase of the house. You can't finance your attorney fees. I guess you could take out some sort of personal loan or sell an asset or something. But my sense is these attorney fees are substantial, as in tens of thousands of dollars. And everything you spend on attorney fees is money you don't have to spend on the purchase of the house. But you are going to be laying in the desert as a dry husk if you try to represent yourself in the circuit court in these matters. And Mr. Hatch has already been allowed to withdraw from the circuit court. There's nothing to do in my court until the circuit court case is resolved. Have the escrow payments as they were restructured been made?
Yes.
Mr. Soltis shakes his head no, you say yes.
Maybe there's a recent payment, but until very recently, they had not, to my understanding.
They've been paid every month. This month, I think, is not in yet, but every month's been paid.
All right. Are you in residence at the lake?
I was, but I'm back in New Buffalo right now.
So has anyone enjoyed the Corey Lake amenities this summer?
No, not really. We got the dock in late, and then needed dock repairs, roof repairs. I had to get a bunch of stuff done, and then you know, we both work full time in the summer, so it was kind of one of those things. We were planning on living there and not commuting, and they got traffic, so it takes 2 hours to get there now from New Buffalo, or it did because of the traffic that they had this summer.
That's
But
the
it's
other
been
thing.
maintained. I've been mowing the yard. I mean, everything's been maintained. The dock's in, everything's working, everything's good.
But let's say things start to break, the water heater goes out.
We had to
the
replace
pump-
all that.
Been replaced. The furnace has been replaced. We have replaced everything in there except for the and I have a set of appliances for my sisters. It's everything in there has been replaced by us. The furnace, the water heater.
All right.
Joe did the deck. He did
Well, let's
Like, we've
hope it
been doing
all
all-
lasts,
That was
because
part
I
of the
can't-
issue. Oh, I'm sorry, Your Honor. That was just part of the
Go ahead.
issue. When Miss Blair evicted Mr. O'Donnell and Miss Bowers without lawful cause, is that she let the house sit over the winter, and then the pipes froze, and then Mr. O'Donnell and Miss Bowers had to then replace the furnace, replace the pipes, and all that was going on after the specific performance order, and those were going to be the damages included in the circuit court for the offset. So I think they are very interested in protecting their own assets that they've replaced inside the house, and is not going to let it go to waste, or the pipes to freeze, or not maintain it, because they have invested $107,000 into this house, and that doesn't include the tens of thousands of dollars to replace the furnace and the pipes and all of that as well.
Your Honor, they aren't living there and have not lived there. You gave them possession, so Miss Blair couldn't get in there and take care of it. So it is what it is.
Oh. Mhm.
We got possession in the summer, Mr. Soltis. I am talking about the winter before that.
Yes, and I was aware of that stuff. All right. I don't know what's going to happen here. But I do believe that it isn't going to be resolved by the time I retire. But I also believe that Mr. Hatch is entitled to the relief that he's requesting. So what needs to happen now, Judge Stutzman gave you until October 2nd to hire counsel or to file an appearance on your own behalf. You are.
He gave us
gonna be
60 days from the, excuse me, Your Honor. He gave us 60 days from the time that it was filed. And I don't think it was filed till like a couple of weeks ago.
All right, well, whatever the deadline is, the attorneys
Okay.
thought it was October 2nd. But there are things that need to be heard in circuit court. They're your claims. You're the counter-plaintiff, and someone is going to need to present the evidence and follow the court rules and the rules of procedure. This isn't a small claims court case. This is a circuit court case for substantial money damages. And you need a lawyer. You have one, and it might make more sense to pay the one you have instead of trying to scrounge up money to pay another lawyer who is also going to give you a substantial bill. The problem that you're in, and I'm not being critical, because so much time and so much money has been spent, you've run out of money. And maybe Miss Blair is about in the same boat.
I think that was her plan, Your Honor.
Well, I don't know. I regret how long this has taken to unravel, but it is what it is, as Mr. Soltis said. So is your plan to try to find another lawyer or just represent yourselves?
I mean, to be honest with you, I was hoping that some kind of resolution would be found in the meantime, but that's not going to happen. And I don't believe it's going to happen.
That's what I was hopeful for today. If I got everybody in the same place at the same time, we could see a way to resolve this. But Mr. Soltis eloquently said, reasonableness is in the eye of the beholder. And you're not this far apart, maybe you're this far apart, but you're not together with a deal. So you're gonna be in the circuit court, and Miss Bowers, so are you. And you're gonna be representing yourselves. but Judge Stutzman has already ruled on that matter. So I don't really like doing it because I don't like leaving you high and dry. No one knows this case as well as Mr. Hatch. No one. Not me, not Mr. Soltis, not even you guys. And when Judge Stutzman got it, he was like, you know, there are boxes worth of stuff and pleadings and counter pleadings and motions and orders. And it was a chore for him to get it into a understandable basis to make a ruling on it. I just don't like what's gonna happen here. Ms. Bowers, you want to say something?
Has there been a ruling on it? I don't even really know what's going on with it, to be honest.
No,
with you.
there hasn't been a ruling on it. All those 7 issues that I removed to the circuit court are still there. The damage hearing and circuit. I'm sorry, go ahead.
It kept getting continued. I think he didn't look at it the first time we went in, and then I don't think he was familiar with it the second time that we went in, and it just keeps getting continued, and then we just keep paying
I
to go
can't
there for
speak to any
nothing.
of the delay in circuit court. One day was due to a flood, so I won't blame anybody for that one. But there was a lot of delay in there, and I don't understand all of it. But as I said, I had my share of delay just from the order on August 5th, trying to get this hearing set. But August 5th to September 12th isn't too bad. All right. Mr. Hatch, is there anything else that should be in the order?
If the order is going to be granted, Your Honor, I would think for practical purposes, because Mr. O'Donnell and Ms. Bowers were given 60 days to either represent themselves in pro per or retain counsel. I think we're going to want to have that clause in here as well. And the proposed order attached as Exhibit 1, it just grants the motion to withdraw. And I think we probably need to either align that date with the date that the circuit court gave, or to give them the same amount of time, 60 days, to find a lawyer in the district court action. I would assume that if they hired a lawyer, they would represent them in both the circuit and the district court action.
Yes.
So by my calculation, the order was entered on August 5th of 2025, granting my withdrawal in the circuit court. 60 days after that would be October 4th of 2025. So I would just ask that they be provided with, and I don't think that between now September 12th and October 4th, when their children are in school and they're busy like everyone else, that's going to be sufficient time to make a decision to either hire a lawyer in this action or to represent themselves in pro per. So they've got to respond to the circuit court by October 4th, but I would ask for the additional 60 days in the district court to file an appearance through an attorney or in pro per. And even if those dates are staggered, Your Honor, I don't think it's going to matter, because the district court action is stagnant until the circuit court. So even if they hire a lawyer, represent themselves in pro per in the circuit court, if they're given another, I don't know what the count would be, 30 days in the district court, I don't think that would prejudice Ms. Blair in any way, and I don't think it would prejudice the court, because it's basically on mothballs until the circuit court makes a decision on the claims. So
I don't know that they actually have to file an appearance to say we're hereby representing themselves. It certainly can be done, but they just are at that point.
I was just thinking, Your Honor, for purposes of for the court's mailings to go out, I think they need the
Yes.
addresses and all of that.
Good point.
Your Honor, and for the purposes, I need to know their contact information as well.
Okay, good point. Good point.
So that was a long diatribe, Your Honor. I got off on a tangent, but I think that the only thing that needs to be added to the order granting the motion to withdraw is a paragraph about when they need to file appearances, either in pro per or through counsel in the district court action. It can really just be a cut and paste job of what's in the circuit court's order.
And I didn't print that order. It's in the circuit court on base file rather than mine, and I should have printed it. Now somebody's here by telephone.
I'm so sorry, it hung up.
Okay. It's Carla Bowers. All right, Mr. Hatch, I'm going to ask you to do that cut and paste job. I'm going to, without any sense of joy, grant counsel's motion to withdraw. I had the order right in my hand.
Any good Michigan lawyers watching this, reach out to us.
Yeah, if anyone's watching this, they want to get in this case, contact the plaintiffs, the counter plaintiffs. All right, you will have 60 days from today's date, which would be August 12th. We'll go to November 11th. That's a holiday, November 12th, to either have an attorney file an appearance on your behalf or file your own appearance, both Carla Bowers and Joe O'Donnell, with your contact information and address, email, telephone numbers, because you'll be representing yourselves. At which point, Mr. Soltis will be able to talk with you directly. Right now, it's unethical for him to speak to you because you're represented by an attorney.
Your Honor.
Yes.
Is there any way we could put something in there that like we could get like a copy of everything? Because I was, we were kind of told that like, the trial thing was over. You know what I mean? I still have the demonstratives at my house, but like I don't have any of the files or the pictures, and we were never really given that stuff. So, I mean, I don't. Do we have to ask for that, or do we have to?
That's fair enough. Are you willing to return the file to the defendants?
Yeah, sure. I think it's my professional obligation or ethical obligation to return. I mean, I could file an attorney charging lien to retain the file. I'm not interested in doing that.
Well, to either forward the file to the new counsel,
yes,
or to the parties.
But I'm not interested in retaining any of the information. I'm happy to provide and will provide electronic copies of every single pleading and paper that was filed in the district and the circuit court to Mr. O'Donnell and Ms. Bowers via their emails that I have.
All right, why don't you put that in the order as well? All right. I'm, as Mr. Hatch says, stagnant until the circuit court takes action in this case. I'm sorry to see it come to this, because it isn't going to end well for anybody. It's just going to take a long time to try to get somewhere. It's in everybody's interest to try to come to some solution to this. Find a number that she can accept and you can accept, and execute either the return of this house to her so she can sell it, or the execution of the specific performance so you can buy it at the agreed upon price. I don't have an answer to the tax lien question. If I knew about it, I forgot about it because I don't remember hearing it before. But the order will say that Mr. Hatch is allowed to withdraw as your attorney for Joseph O'Donnell and Carla Bowers. You have 60 days from today, which will be November 12th, to either retain new counsel that files an appearance or file an appearance on your own behalf with your name, contact information, including address, telephone number, and email address. It will also say that Mr. Hatch shall return electronic copies of all pleadings and filings and exhibits to you for your utilization in the circuit court case. Right now, Mr. Soltis is on thin ice talking to you guys. So he's not gonna have any communication with you until after November 12th, when you either represent yourselves or you hire new counsel to represent you.
Your Honor, if I may interject, the circuit court order has a date of October 4th. At that time, I believe I can contact.
Yes, I guess, you can, fair enough. After October 4th, you guys can communicate.
He can communicate with respect to the circuit court claims, but he cannot
Yes.
communicate with respect to the district court claims.
Yes, and that includes the damages claims and the other matters. So effectively, what Judge Stutzman's order did is vacated my order regarding personal property, and left the other things sort of as they were. He had a different view of MCL 600, but 8303. All right, Mr. Hatch, I don't know when I'll see you again, when you'll have cause to come to St. Joseph County. I thought you did an excellent job for your clients. And Mr. Soltis, you and I will probably see each other in the future. Mr. O'Donnell and Ms. Bowers, I hope you can move forward in this. But that's what I've got. Ms. Stiver?
Yes,
Stay in contact with Mr. Soltis.
I will.
And that's all I've got for everyone. All right, you're all good to go. Thank you.
Thank you. I just want to say
Thank you, Your Honor. Oh, go ahead.
always is a pleasure to be in front of you. And I don't take any joy in this either, but it's always a pleasure to appear in your court. And I'm going to make my way down there either for personal or professional reasons again to see you before you retire.
Well, it is Fair Week next week, so if you're coming, you got an extra elephant ear in your future. That goes for you and Mr. Bowers, or Miss Bowers and Miss O'Donnell. If you got to file some pleadings, do it next week and go to the fair. All right, you're all good to go. Thank you.
Thank you. Thank you, Your Honor.
Very good. Thank you, Your Honor. Best of luck, Mr. Bowers and or Mr. O'Donnell and Ms. Bowers. Take
You'll
care.
be in contact.
I'll be in
All right,
contact
thank you.
for the order. So thank you.
Take care.
All right.